Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about a really simple change that could be made to the law that would do a lot to help protect domestic violence victims. And when I say really simple change to the law, this is going to be a short video, and you know how much I love to talk. Now, this is also a good illustration of how a law that's passed without sort of sitting down and really thinking out the possible consequences can harm people in a very real way. So the section I'm looking at here, this is from the Residential Tenancies Act here in Alberta, but lots of other provinces have similar provisions, and in fact, similar provisions exist in the laws all over the place. This is a very common kind of issue. So if you are not living in Alberta, you'll need to check your local laws to see if they have the same problem or if they handle things a little differently. So the section I want to look at is Section 24. And again, this is the Residential Tenancies Act. What it governs is residential tenancies. When you rent a place where you plan to live, like a house or an apartment, not so much when you're renting a storage locker. But this section says neither a tenant nor a landlord shall add to or change locks on doors giving access to residential premises or to the property of which the residential premises form a part without the consent of the other party. So this applies to both like the front door of your apartment, but also to the main door of the building, or if there's a gate around, a house or something like that, all of those things. And it basically says that neither side, the landlord or the tenant, can add to or change the locks without the permission of the other half. Now they go on to have some exceptions here. Notwithstanding subsection 1, the part we just read, a landlord, but not the tenant, may add to or change locks on doors giving access to residential premises or to the property, if a key is made available to the tenant as soon as the addition or change is made. So they can change your front door lock, but they have to give you a new key. You don't have that same power. And there's another exception here that says that subsection 1 does not apply to the installation by a tenant of a security device that 1 is capable of being put into effect only while a person is inside the residential premises, and 2, can be installed and removed without damage to the premises, or will remain affixed to the premises and become the property of the landlord when the tenancy is terminated. So what this means is that as a tenant, you have the ability to add a lock, but it has to be a lock that is of a sort that you can only, enable while you're inside. Something like a chain lock that you see on those hotels and so forth. Now, a chain lock is not terribly secure. They're not a great option, but that is kind of the idea. And it has to be something that doesn't cause any damage, and damage can include fairly minor things, or it has to be something that will be permanently attached. But this says that you've got the ability, you're allowed to install something like that, so long as you're willing to leave it behind. And where a tenant adds to or changes a lock in accordance with subsection 1, so again, with the permission of the landlord, the tenant must make a key available to the landlord as soon as the addition or change is made. Now, you might be thinking, what is the big deal here? This seems fairly straightforward. The problem is what happens when people are in abusive relationships, because the victim of domestic violence will often get an order that bans the aggressor, or at least the alleged aggressor, and all of that has to get sorted out in court later, but bans them from returning to the house. It says, okay, if you're the victim, or at least the person we think is the victim right now, you need this protection. We're not going to force you to move out, but we're going to tell that person that they can't come there. Well, that's great, because what you have there is a piece of paper, and that piece of paper might be enforceable by calling the police, but the police take a while to get there. And that person, the person who's been the subject of the domestic violence, then goes to their landlord and says, hey, I would really like to change the locks. And the landlord says, no, we don't want to do that. And we don't want to let you do that. And this particular provision says that they are stuck with that. They don't have any option. And sure, you can add in some sort of deadbolt or, sliding bar or something like that that prevents somebody from coming in while you're home. But that doesn't do anything to prevent somebody from coming in while you're away. You go to work, and this happens to people. A woman who is the complainant in domestic violence goes to work and comes home and finds her ex-boyfriend sitting on her couch. and he wants to have a loud, angry talk. This is not good. And, you know, this happens to both genders. I want to make it clear. So how do we fix this law? How do we make it better? Because, of course, you know, I said, hey, we can change this. One option would be to just say that a tenant has a right to demand a key change. And so that would allow landlords to still maintain, you know, a mastering system. And you can put in a provision that says, you know, a reasonable, you know, some reasonability limit on this, in the sense of, you know, a reasonable number of times per year or in reasonable circumstances to believe that a key change is required. So that, you know, prevents you from just saying, hey, I want to change this every 2 weeks, and, you know, forcing them to, you know, bring up locksmith costs. You could also put the cost onto the tenant. You could say that a tenant has the ability to insist on a key change so long as they're willing to cover those expenses. That way they can't sort of abuse it. You could also put in provisions that allow for where there has been a charge related to family violence, or where an emergency protection order has been issued, that the tenant then gets the right in this to unilaterally change the keys. All of these would be really simple changes to make, and would enable a tenant to protect themselves against these kinds of situations. Now, I should caution, a lot of people put a little bit too much stock in locks, and a lock is not sort of a magical barrier. It doesn't stop people necessarily. Perhaps I'll do some videos in future talking about how you can upgrade your security to make it much more difficult for people to come in, because a lot of people's locks and security are not great. Some of these are things that you can implement even if you happen to be living in an apartment building. So that wouldn't contravene this kind of rule. But I think this is a really simple sort of change. This would be something that would be a very positive development. And I've seen a lot of situations where people who have been the victims of this kind of thing do find that their previous partners come over and let themselves in. Maybe because they want to do violence, maybe because they think they want to talk, and that transitions into violence, and sometimes just because they want to cause damage in other ways. They want to come in and take, they want to come in and take property. They want to come in and damage property because sometimes they're in a mood for revenge. So they come in and start destroying photographs. They, throw out somebody's laptop that has their dissertation on it. All of this kind of thing. It's, at least we can make it so they have to break the locks before they get in. So I said quick video. Hopefully this one will end up being under 10 minutes or close to it. That's kind of my thought. I'm not normally a there ought to be a law kind of guy. Normally I think that, but this is really a situation where we have a law that is intended to protect the landlord, and really it's the tenant who's got to live with the place, right? So I think that there should be some better protections in this particular case. I'm not the sort of person who just, thinks that the law solves all problems, but here the law is preventing some people from trying to solve their own problems, and that's usually a worse thing. Anyway, thank you for watching. Please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level, Canada's National Firearms Association, the CCFR, and the Canadian Shooting Sports Association. At the $30 level, Sights and Arms Limited. And at the $20 level, Mark, Jane Babin Luxor, Haywire, Dale Nesbitt, Cameron Johnson, Bruno R., Andrew Elsich, and Vicky. Thank you as well to all of my supporters at the $10 level who will be in the crawl immediately following. My apologies because I forgot to include the crawl last time, but I will make sure to do it this time. Thank you for watching, and I hope this has armed you with knowledge.